Is an adopted son a son? I ask because two of my siblings spent 14 months and approximately £43,000 in legal fees arguing that the answer was no. And I want you to understand that the answer is, in fact, written down in a piece of legislation they apparently did not read before they started. My father died in January without a will. This was not a surprise to anyone who knew him. He had been talking about writing a will for 15 years, with the specific conviction of a man who fully intends to do something and has confused intending with doing. He had mentioned it at Christmas. He had mentioned it after a health scare in 2019. He had mentioned it to me personally on at least 4 occasions, and each time I had said, yes, you really should, and each time the conversation had moved on to something else, and here we are. His estate passed under the rules of intestacy, the legal framework that distributes assets when someone dies without a will, to his children in equal shares. He had 3 children, me and 2 half-siblings from his first marriage, a son called Philip and a daughter called Claire, both of whom I had known since I was 7 years old, and both of whom had apparently been waiting for an opportunity to revisit the question of my place in the family structure. The opportunity, it turns out, was my father's death. The retention anchor. Under the Adoption and Children Act 2002, an adopted person is treated in law as the legal child of their adoptive parents for all purposes, including inheritance. This is not a grey area. It is not subject to interpretation. It is a clear statutory provision that has been in place for over 20 years. Philip and Claire had instructed a barrister. Somebody had presumably been paid to advise them. I genuinely do not know what that advice contained. I was adopted at the age of 2. My father raised me. I grew up in the same house as Philip and Claire when they visited. I attended the same family events. I was at my father's bedside when he died. These are not details I am including for sympathy. I am including them because my half-sibling stood in a solicitor's office 4 weeks after the funeral and argued, with apparent sincerity, that I had not been a real part of the family structure my father had intended. I had to sit in that solicitor's office and listen to that. The particular absurdity of sitting in a room and being told you are not a real son by people who had known you for 36 years is something I cannot fully convey. But I will tell you that my instinct, which I suppressed, was to laugh. Not because it was funny, because it was so precisely the wrong thing to say in front of a solicitor that I could not work out how anyone had decided it was a strategy. My solicitor was a man called David, contentious probate specialist, with the suppressed amusement of someone who has seen this argument made before and knows how it ends. David said, "The Adoption and Children Act is quite clear." He said it in the tone of a man reading from a menu to someone who has ordered something that is not on it. The business premises were the setting for the main dispute because the largest single asset in the estate was my father's share of a small engineering firm he had co-owned for 22 years. The firm's premises became the de facto headquarters of the dispute. There were 3 hearings conducted in a room above the workshop, which I found appropriately undignified given the circumstances. Philip had produced, at the second hearing, an agreement he claimed my father had made with him regarding the business, a written document suggesting that Philip would inherit his father's share, regardless of any intestacy distribution. The document had not been witnessed, it had not been signed by a solicitor, it had not been mentioned to anyone in the family before Philip produced it in a dispute about the estate, an agreement nobody had ever seen. That arrived in a dispute about who the real family was. The midpoint of this story is when David asked for the document to be independently examined, which Philip's legal team declined. David made a formal application for the examination to be ordered by the court. The examination was ordered. The examination found the document to be printed on paper that, according to the forensic analysis, had not been commercially available before 2018. The agreement was supposedly dated 2011. Philip's barrister withdrew from the case the following week. Withdrew. Philip and Claire's solicitors offered to settle at that point, a reduced share of the estate in exchange for dropping the contested distribution. David recommended refusing. I refused. The settlement was not accepted. The case proceeded to a final hearing at which the intestacy distribution was confirmed as equal shares among 3 children, one of whom was me, all of which is written down in the Adoption and Children Act, and had been written down there since before Philip had apparently decided to test it. The estate was distributed in equal thirds. I received £122,000, net of legal costs. The costly part is not the legal costs which were awarded against Philip and Claire. The costly part is the 14 months. My father died in January, and I did not properly grieve him until the following March, because for 14 months every thought about him was interrupted by a legal proceeding. I have not spoken to Philip or Claire since the final hearing, and I do not expect to. We were not close before. The hearing finished whatever was left. I still work near the business premises. I drive past them occasionally. The workshop is still running. A different family owns it now. The room above it where we held 3 hearings about whether I was a real son has been converted to storage, which is, I think, exactly the right use for it.